Good evening, everybody. Sorry for the technical difficulties that we have been encountering. I want to welcome you to the joint collaboration, I will say, between Carnegie Library, Allegheny Law Library, and Pennsylvanians for Modern Courts. We have a series of programs, and tonight's is Your Rights in Civil Court Matters. And we have as guest speakers Larry Walker and Mike O'Donnell, who are both partners at Cozen O'Connor. Let's see if I can do this. Okay, as a few little primers. If you have any trouble connecting or technical issues, just email us at staff@PMC Online. This webinar workshop will be recorded and available on PMC's website, on Allegheny County Law Library's website, and on the Carnegie Library website. Most importantly, we are here to provide information. We are not giving any legal advice. So if you have questions after this program, you should feel free to reach out to PMC. We have a hotline number, or email us, and we will see if we can direct you to the appropriate advice. Okay, let me tell you a little bit about. First, I want to say something. So Lori Hagan is on, and I want to say, Lori, thank you very much. Lori is here with the Allegheny County Law Library. They're a tremendous source for resources, and you can always reach out to Lori to ask for assistance. Lori, do you want to say anything?
Yeah, we're located in the 9th floor of the City County building. Open from 9 to 4:30 Monday through Friday. We have an email that you could send requests if you have information that you need, acll@duq.edu. And again, we can give you legal assistance on information, but not advice. So we cannot do what an attorney does, but we can help you find more information on your topic as you need it. A couple sources that I talked about quickly earlier was Pennsylvania Causes of Action book by Beisel, which talks about the elements of each cause of action and explains it, definition. It's a wonderful book. And we have a second one that's Pennsylvania Causes of Action that's published by the Legal Intelligencer, I believe out of Philadelphia, if I'm not mistaken. So
okay. Thank you. So this program is actually being seen as a collaboration between Allegheny, Carnegie, and we've also brought in Chester County Library. And so that we are going to try to apply this across the state. So everybody knows in Pennsylvania, we have 67 different counties for court systems. So there may be differences in each county, but in general, the law is the same. So PMC is a legal nonprofit that was established over 30 years ago to support merit selection, but merit selection has not yet come to pass. So in the interim, we are advocating for access to the court system and advocacy for judicial reforms. Most importantly, this is an election year, 2023. That means that we are electing judges in Pennsylvania. We have one Supreme Court, 2 Superior Court, 1 Commonwealth Court for the appellate courts. Please look at our website and educate yourself about the candidates and the positions for which they are running. Okay, we have a criminal court workshop coming up. There's no date on this next week, I know, but it's on our website, www.pmconline.org. And this is our agenda tonight. We have a lot to cover, so I'm going to speak quickly in the beginning. And we're going to talk a little bit about our Pennsylvania court system, because you need to know where these civil litigation matters fall. We're going to do a quick primer, I will say, in Civil Litigation 101. And then we're going to talk about, what do I do about my neighbor's tree? We had received a number of phone calls from magisterial district court judges telling us that there are they have been inundated in the fall with tree complaints. So we reached out to some experts, I will say, who are going to help us figure out how we should be handling them. And then if we have time, but probably not, I wanted to list other types of civil litigation matters, such as breach of contract, automobile accident, consumer rights, insurance disputes, which we will have programs in the future, but just so that you know that they are out there as civil litigation matters. So a little bit about the structure of our Pennsylvania court system. I mean, Larry or Michael, do you want to handle this or do you want me to?
Sure, I can jump in, Deb.
Great.
As well. And Mike, anytime you want to jump in as well. In Pennsylvania, we have a system, as you see, set up on the screen in front of you, where at your lowest level, your small claims cases, traffic court cases, and things of that nature are typically handled at your local level in your local community, at the municipal court and magisterial district courts. So if you were talking about a very small complaint, typically less than $15,000 in damages, you would file your complaints in the municipal court or the magisterial district courts in your community. The next level, which is where Mike and I practice most often, is in the Court of Common Pleas. That's in your civil litigation matters that are above $15,000. That would be where you file your civil lawsuits against someone for, again, a civil matter in excess of $15,000. And then once you conclude your matter at the Court of Common Pleas level, you may appeal that matter. And typically in your civil matters, you would be appealing to the Superior Court of Pennsylvania. In Pennsylvania, unlike most states, in fact, I'm not aware of any other state like Pennsylvania that has a separate appellate court that handles appeals for typically governmental matters or matters of equity. And so the Commonwealth Court is not one that I would expect anybody listening to this to actually be participating in, unless you were suing a governmental agency and you filed an appeal to this, just filed an appeal. So civil matters, like we're going to talk today, would be appealed to the Superior Court. And then once you conclude that matter in the Superior Court or in the Commonwealth Court, your next level of appeal would be to the Supreme Court of Pennsylvania, which is Pennsylvania's highest court. The Pennsylvania Supreme Court, you do not have an automatic right of appeal like you do to the Superior Court. With the Pennsylvania Supreme Court, you will have to file for a particular type of appeal, and the Supreme Court would review that and make a decision about whether it decides to hear that case with respect to your, what I would call your garden variety civil cases. There are cases that have the automatic right to appeal, which would include cases like the death penalty and interpretation of the state constitution. But putting those aside, the Pennsylvania Supreme Court does not automatically grant you a right to appeal.
And so this is a lot of what you have said already.
Yeah.
This slide. So go ahead.
I was just going to say, you can probably blow past that,
right.
Slide as well.
The only thing I want to say here is that, and it's really important in my mind, so I'm going to interrupt you, but we have 6 judges right now on our Supreme Court. We have 1 vacancy, as I mentioned, but what's most important is that the president judge is Deborah Todd. She was just installed last week as the first female president judge that our Commonwealth has ever seen. So that's in 300 years. So it is pretty remarkable that Pennsylvania has come into the modern age. And just also another tidbit that the Supreme Court is actually the oldest Supreme Court in our country.
I think it's probably worth mentioning too. A lot of people hear Supreme Court. We're talking Pennsylvania Supreme Court, right, as opposed to the federal Supreme Court that you might see making news a little bit more prominently. So it's 2 different tracks, but it's same concept at the end of the day.
Yep.
Right.
And the other issue is, so that everybody knows, our Supreme Court does more than just decide cases. So it has a lot of administrative oversight. There is a judicial conduct board. They oversee judicial behavior. They oversee lawyer behavior. Lawyers. I mean, so it's important that there is this authority, supervisory authority, that will oversee and control. It has a number of boards and advisory groups, but there is this administrative and regulatory part of the Supreme Court activities. And we did discuss the appellate courts. This is just a picture of our appellate court, our Commonwealth Court, and I will also just mention, because it's hot off the wire, the President Judge Jubileer, she just issued a 786-page opinion. I have never seen an opinion this long. Today, less than an hour ago, saying that the Pennsylvania Constitution provides a right to funding for education. So it is truly, I haven't read it yet, but to me, it's a remarkable decision, and I can't wait to read it.
Deb, can you send that to me if you have it?
Absolutely.
Thank you.
Okay, and this is our Superior Court. As I mentioned, it has 2 openings, and so you will be voting for a candidate in the primary and then in the general. And as Larry mentioned, there is this automatic right of appeal to the Superior Court from a decision in the Court of Common Pleas. And then we discussed this, so we'll go to Civil Litigation 101.
So I'll just jump in here for a little bit. I am not a criminal lawyer, so I'm not the person you want to talk to about those matters. But with respect to civil matters, they typically involve a plaintiff, who is the person that brings the lawsuit, and a defendant, who is the person who is being sued, right? So the person filing the suit or suing someone is the plaintiff, and the person who's being sued being the defendant. And the question with respect to a civil suit is not guilt or innocence. With respect to civil matters, it is whether the defendant is liable, or either breached a contract or was negligent, depending on the cause of action that you bring. But the question becomes civil liability, not of course, criminal. The burden of persuasion is always with the plaintiff. The plaintiff carries the burden of proof, and is required to prove its case by a preponderance of the evidence, which means more likely than not. You do not, corporations in Pennsylvania and most states are required to be represented by an attorney, but you are allowed to represent yourself in civil litigation matters. So there's that. You can file a pro se lawsuit and represent yourself in any civil matter, and that includes defending yourself. Deb, do you want to touch on the criminal stuff at all?
Sure. So just briefly, because we do have a program on criminal law, which I can't remember if we have. I know we have one scheduled, as I said, with Philadelphia Library, which will be on video. But it is a case brought against an individual by the state, by some kind of state agency, to determine whether the defendant, that's the individual the lawsuit was brought against, has broken the law. And there are many different methods and ways and rules about breaking the law. However, here what's important is there's a difference in the burden of proof. The prosecutor must prove guilt beyond reasonable doubt, and there is a right to an attorney. So maybe and the right to an attorney is you can have is not dependent on on whether you have money or not, because you will be provided, the court will appoint an attorney on a defendant's behalf if you cannot afford an attorney. And that's a very important distinction here, because you should be represented at all times. Okay. This is the beginning of a civil case. So Larry, I'll pass back.
Sure. So this is where the rubber meets the road, really, with this presentation. Mike and I would tell you that any lawsuit always starts by gathering the facts, right? Get the evidence, get the information that is going to be important to your case. That includes the names, the pictures, if pictures are necessary, witnesses, documents, things of that nature. Gather all that information and have it available to you when you begin to decide whether you're going to bring a case and if you prepare your complaint. With respect to a contract, you want to ask yourself if it's an oral contract or it's in writing. If it's in writing, you need to have a copy of it. Typically, Pennsylvania rules, particularly in the Court of Common Pleas, require that you attach a copy of the written agreement to the complaint when you file it. And if it's an oral agreement, you have to say that it's oral, and then you have to identify what the terms of the contract are. there's a note here about duty. I don't want to get bogged down into that. Legal duty is a very complex issue. It's typically a matter that's resolved by the court. What I would say about duty is this. As a general matter, in order for someone to be responsible to you civilly, they have to owe you a duty. And that duty can arise either by contract because someone agreed to do something with you, or by law, operation of law, which would be like a building code or some other local municipal law. Or it can arise in very other limited matters, but due to a relationship that you may have with someone like that. The question really becomes for most of the people who will be watching this is whether you have been harmed and whether the factual pattern involving the harm to you stems from a law, like either a traffic violation or a building code violation or a property law that may exist in your township or an ordinance, something of that nature. That would give you the basis for the legal duty that you may prosecute a claim against your neighbor. Some of the things we're going to talk about here today are hazards like trees, trespass, which we'll get to when we start talking about trees that start growing over the line, and whether then, of course, that the defendant in the case has breached the duty. And that's always going to be an element that you have to prove, not only that there was a duty, but there was a breach of that duty that was owed and that it actually resulted in some kind of harm to you. And when we get into the trees, for example, we'll talk about a tree encroaching on your property is a harm on you. It's an impairment to your property rights. And therefore, if it grows across the property, it's a breach and it has harmed you. We'll talk about that a little bit later. So let's jump in here. So for contract action documents, we talked about this. You want the written document, or if it's an oral agreement, what the terms are. And negligence is another cause of action that is probably the most common cause of action. Negligence really is, I would say, defined as a lack of reasonable care, right? The amount of care that a reasonable person would use under a particular set of circumstances. And when someone fails to act with that care, they may be alleged to have been negligent. And the kinds of things that you might use to prove a breach of contract action or a negligence action would include, obviously, the contracts that are involved or documents that are involved, invoices, estimates, pictures, affidavits, which are sworn statements from witnesses, which may be workers or co-workers or doctors, neighbors, police officers, things of that nature. You may want to get statements from under a particular set of circumstances. And then, of course, you always have to prove your damages. So you'll need estimates. If you hired a contractor to fix damage as a result of a tree, you're going to get copies of the estimates that you paid to fix your house, or the costs associated with cutting the trees. You'll need that for the purpose of the lawsuit. So what this next slide is talking about is what court do you want to file in? So, for example, if you lived in, and we're talking about the state of Pennsylvania, but if you lived in, for example, Bradford County, and you lived in maybe the Mansfield, Pennsylvania, or the Troy, Pennsylvania area, which are small towns in Pennsylvania, they have their own magisterial district court. So if your neighbor had a tree that was encroaching on your property and it was a small case, you would go to the Troy area magisterial district court and you would file your complaint against your neighbor. If it's a case that has a value more than $15,000, that is the kind of case where you would file a civil lawsuit, and you would file that lawsuit in your county court. If you were in Philadelphia or Pittsburgh, for example, Philadelphia would be filing in the Philadelphia Court of Common Pleas, or with respect to Allegheny County, you would file in Pittsburgh in the Court of Common Pleas. And there's paperwork available, and it's very easy to go online and go to the Court of Common Pleas. Here's a copy of it. You can go into, for example, the Philadelphia Court of Common Pleas, put it into Google, and I'm sure in a minute you would find a copy of this form. You can either go there in person and get yourself a copy if you don't have the ability to print it out, or you can print it out and hand fill in the appropriate information in here, your name, your address, what it involved. The next slide here is this is a form that the Court of Common Pleas gives you to file, and I would assume it's this is also a form that can be filed in the magisterial district court. This may just be the magisterial district.
Well,
form.
they're very similar. So
Yeah.
the website, like the Pennsylvania court website, which is the website run by our Supreme Court and our administrative office of the Pennsylvania courts, has forms. And then usually, but not always, if you go to the court's website, there are forms also. So for Allegheny County, it's the 5th Judicial District. For Philadelphia, it's the 1st Judicial District. And there are, as Larry said, lots of forms online, but you can also call the clerk's office and ask for assistance.
Yeah, they're very helpful. They will not give you legal advice. They'll be sure to tell you that, but they will tell you what forms you need. They will tell you how much the check has to be. They'll tell you where you have to take it. They'll give you a lot of very basic information that helps you walk through what forms are necessary, how much it costs, and where to file it, and how to serve it. Because once you file a lawsuit, you have to serve the defendant with the lawsuit. You may not want to knock on your neighbor's door and hand it to them. That can be somewhat uncomfortable and can be argumentative. You may want to just follow the service of process procedure, which includes, under certain circumstances, regular mail, and other circumstances, the sheriff may serve, for example, in a Court of Common Pleas case, the sheriff in Pennsylvania makes service of process.
Okay.
I'll jump in here. I guess looking at it from the opposite side now, we've been talking a lot about starting a lawsuit and filing the complaint as a plaintiff. What happens if you're the defendant in an action, if you have been sued? Just like Larry pointed out, you would have been served with a complaint of some type. Let's say it's from the Court of Common Pleas and the sheriff knocked at your door. As we say here, you want to attend any hearing, but even before that, take a look at the complaint. They'll usually come with a notice to defend, and it'll tell you how long you have to answer that complaint. If you have 20 days is typically standard, you're going to want to file your answer. That's a written document you're submitting with the court. And that lets the court know that, all right, I'm defending myself in this action. What you don't want to have happen is to ignore it, to ignore the complaint, to ignore the hearings. And at that point, a default judgment might be entered against you. That's the court's way of determining, without you defending yourself, that you are culpable or liable for what the plaintiff has alleged. So you want to make sure that you're not ignoring these things. You want to make sure you're proactive in that response. Looking at the next slide we have here, your response to a lawsuit, here's some practical real world analysis. If you're being sued for an amount of, not damages, an amount of money, you can try to negotiate it down. If you know the other party, if you have a relationship, you could always try and work these things out, talk them down, see if you can negotiate a lower sum. There are dispute resolution services out there, depending on your jurisdiction where you are. They might be able to assist you in that endeavor, might be able to help you come to some sort of compromise if there is one to be made. So I would encourage anybody to seek those out and see what they can do for you.
And I'll just jump in here real quick too, Mike. If the matter gets away from you, in the sense that you file the answer, but you haven't really had an opportunity to talk with anyone, and you get scheduled for example, a trial at the magisterial district level, and you show up to court and it's trial day, the court will often work with the parties and mediate and try to reach a resolution before the judge has to hear a trial and issue a verdict that one or both parties may not be happy with. So one idea for you, if you get to that juncture where you're actually in court, is to ask if the judge would agree to mediate the case or talk with the parties about an amicable resolution before the case actually has to be fully tried.
So here's a good slide to kind of look through your little checklist of, now that I've been sued, what are my options? So broadly speaking, you can hire an attorney. We would also encourage you to call your insurance company, homeowners insurance, renters insurance, vehicle insurance. There's many lawsuits out there that insurance carriers will hire an attorney and defend you for. There's many that they won't, but you don't know until you make that call, and depending on your circumstances, it's certainly one of the first things you want to do. And then, of course, you have the opportunity to represent yourself. If those first two choices there aren't at your disposal, then
and just to jump into on this, Mike, you would be surprised at the breadth of insurance coverage. It's some of the things that, you know, they can cover fights and like injuries that happen as a result of fights. I mean, I'm not a coverage lawyer, so I'm not saying they do, but you'd be surprised at the breadth of things that are covered by your homeowner's insurance. And a lot of people don't know that if you have homeowners property insurance or auto property insurance, there is a liability side of that policy as well that provides a defense to you for certain matters. So don't be hesitant to think of your insurance company as a first call, because it costs absolutely nothing to pick up the phone and call your insurance company and ask if there's coverage for a particular claim.
The worst they can say is no. Yeah, and renters insurance too. You know, it's there's a broad coverage out there sometimes, so it's worth asking.
And then there's counterclaims, and that's what this slide talks about. So if you've been sued, and we'll talk about this in a little bit with respect to trees, for example, if your neighbor, let's say, you know, cuts down all the limbs over your property line, and they file a lawsuit against you for the costs associated with cutting all those limbs. And lo and behold, you find out that not only did they cut some of the limbs, but now they've also cut down some of the trees, including the trunk right down to the base. And some of those trees that they cut down are on the property line. As it turns out, and you'll learn here in a little bit under the law, it might be that your neighbor, depending on where that tree was located, went a little bit too far, and you might be able to file your own lawsuit against them, which is called a counterclaim. So in response, you're not only filing an answer to the counterclaim, responding to their specific allegations, but now you're filing your own counterclaim, which is in essence saying, not only do I not owe you money, but you owe me money, or it's a wash. So now we'll get into the substance of this. And Mike, if you want to just take the lead and jump in, I'll follow behind you.
Sure. So now let's talk about trees, right? If we go to the next slide, there's three main scenarios that we typically see here when dealing with a neighbor's tree. And keep in mind, when we're talking neighbors, you know, we might be talking residential neighbors, but there's also commercial neighbors if you live next to a commercial property, if you live next to a governmental property. So in the broad sense, when we're talking about neighbors, it's anybody's land who is adjoining yours. So there's three main categories of scenarios here. The first would be where you have a healthy tree encroaching your property line. This, for example, could be your neighbor's oak tree is maybe its roots, its base is 3 or 4 feet from your fence, your property line, but its branches are starting to hang over. Or maybe you're noticing that the branches are starting to fall onto your property. That's what we mean by a healthy tree encroaching over the property line. It's actually coming into your space over the line dividing the two lands. The next scenario would be an unhealthy tree that's presenting a danger or a hazard. So this might be a scenario where the tree on your neighbor's land, on your neighbor's property, is entirely within their land. No branches overhanging, the roots, the base is entirely on their property. But from your vantage point, you can see it's unhealthy. And that's giving you concern, right? You don't want the tree to come down. You don't want it to fall onto your land. And you're noticing that it looks unhealthy. And that kind of leads us into
I was going to say, and Mike and I have handled some of these cases. Our specialty, by the way, is catastrophic property damage. So the cases that we've handled are really not along the lines of somebody complaining about a branch across the line. It is the giant 150-foot tall dead oak tree or dying maple tree that fell over and cut someone's house in half. and maybe even injured some of the people living in the house. Those are the kind of cases that Mike and I have handled in the past. And we'll tell you some more stories about it along the way here. But yeah, so the third scenario here is the property damage from neighboring trees, which is the kind that I just talked about, when that tree falls over and causes damage to your car or to your home. So the first thing we're going to talk about is the first topic that we addressed, which is the healthy tree that is just encroaching on the property line. And, you know, we don't want to get bogged down too much in case law, but guess what? That's what, you know, that's where we learn what the rule is in the case law. And if there's one case that you want to read in Pennsylvania about tree law, it's Jones versus Wagner. This was a superior court case, which means that it was a case that happened at the trial level in the Court of Common Pleas, and then it was appealed to the Superior Court. And if you look in the citation here, you see the words that say cert denied. And what that means is that the winner of this case, or the loser of this case, more likely the loser than the winner, the loser of the case at the Superior Court level, meaning there was a trial, there was a result, it went up to the Superior Court, and then someone appealed to the Pennsylvania Supreme Court. And that process was called certification to the Supreme Court, and the Supreme Court denied certification, meaning that they chose not to hear this case. And that can have implications, because what it means to trial level judges and Superior Court level judges that hear these cases, they would look at this and say, okay, the Supreme Court read this, someone asked them to hear the case, and they elected not to hear it, which gives an appearance, if nothing more, that the Supreme Court is giving that opinion the nod. If they had seen something that they didn't like, they may have taken the case. So this case, Jones versus Wagner, involved a case of adjoining landowners that had a property line, a fence separating their properties, and there was a row of hemlocks on that tree line, along that line, the property line, and the limbs were crossing over the property line. And I feel like this is reminiscent of what's going on in my neighborhood right now, because we have this right down the street from my home. There's two driveways that separate two homes, and between those two driveways is a row of hemlock trees. And they are on the property line. They were planted by one of the property owners 25, 30 years ago. They're now 100 feet tall. They drop sap all over the trees, all over the cars. And the neighbor who is closest to me complains endlessly about it, because he is tired of cleaning the sap off his trees. And he wants to cut all of these limbs off these 100-foot tall trees and sue his neighbor. Of course, I don't want to touch it with a 10-foot pole, because they're my neighbors, which is the problem with these cases. It typically involves neighbors and bad feelings, and you have to live with your neighbors. Anyway, in this case, the neighbor got tired of that sap, apparently, cut all these limbs off at a cost of $31,000, and then sued the neighbor who owned the trees for the cost of removing all those limbs. Apparently the trees died. The party who cut the trees down got sued by the neighbor who owned the trees for $31,000, and the court addressing that case for the first time in Pennsylvania clarified the law in Pennsylvania, which is that when branches are crossing a property line, it is a trespass. It does not require intent. No one has to intend that that happens. The limbs merely need to cross the property line. And the court said very clearly, you have options. The first option is what the court called self-help, which means you can cut those limbs off, but you can't cross the property line and cut the limbs off beyond the property line. You can cut the limb to the extent it crosses into your property line and right at that line, but you cannot cross into the neighbor's property to cut any additional, like if you wanted to take it all the way back to the trunk of the tree that's on your neighbor's property. If you were to cross the property line, you would be committing a trespass. The next thing that the court said is that you don't necessarily have to do that yourself. You can also hire someone else to do it and then sue your neighbor for the cost of doing it. So for example, if you don't have the physical capacity to go out in your yard and get up on a ladder, or if the limbs are even taller than that, you don't have to do it yourself. You can hire someone to do it, and then you can sue your neighbor for the cost. Again, we are only talking about branches here that extend over the property line. So you can hire someone to come in. You, of course, want to make sure you know exactly where the property line is so there's no dispute. You don't want to cross into the neighbor's property or hire someone to go into the neighbor's property. You want to cut those limbs off right at the line, and then you can give your neighbor the bill. If they don't pay it, you can actually sue them for it.
And that's probably worth emphasizing, Larry, that we're talking about branches that are just purely existing. They're not even dropping. They're not causing damage to your home. You know, they're not causing any physical damage yet. They're purely just on your property, right? They've crossed that property line threshold that we keep bringing up.
Right. The rub here is the trunk of the tree. Okay. If the trunk of the tree, and the rule was cited in this case, Wolfinger versus Motes, which is a D&C case, which means it's not a Commonwealth case. It was handled at the district court level. So the rule, though, that case has been cited with on multiple occasions, and it's good authority. It's been approved by higher courts in the Commonwealth Court and the Superior Court as well. And basically what the court in Wolfinger said is the rule's different with the trunk of the tree than it is with the branch of the tree. If the trunk of the tree comes out of the ground on the property line, you cannot cut down the trunk of the tree without the neighbor's permission. So if we imagine for a moment a scenario where these trees are literally growing right on the property line, and the trunk comes out of the ground and the property line traverses the trunk of the tree, you could, on your side, cut all the limbs that are coming off the trunk of the tree up to the property line, which can include right against the edge of the trunk. But you would not be allowed under Pennsylvania law to cut the trunk of the tree. So don't do that. Same thing with roots. You can do roots that are on your side of the fence, but if a root, in my view, I don't know that there's a case that decides this issue, but a root, where a root starts and stops is, a whole issue. So some trees like maple trees have lots of roots that are above ground, and roots come right out of the base of the tree. So a root coming out of the base of the tree might be perceived as a trunk, and you really don't want to touch anything there unless it's very clear to you that it has crossed into the property line and is not part of the trunk of the tree.
And Larry, that's a good example too of when you're seeking self-help, when you're taking care of these trespassing branches, roots, you have to be cautious that you're not causing damage to that tree, right? So if you talk to any arborist out there, any tree expert, they'll tell you that there's certain cuts that you can make on a branch or a limb that can actually cause further harm downstream into the tree itself. And it might cause that tree to die. It might cause it to get some sort of disease. If that happens, the table and the coin can be flipped now, right? So say you sought self-help and the manner in which you conducted it has now caused damage to that tree on your neighbor's property. You can be liable for causing that tree to die, to become diseased. So when you go about this, you want to either make sure you know what you're doing, or if you can, consult an arborist, a tree expert in your area who might be able to serve as your contractor here and take that conduct themselves. But again, every scenario is a little different.
This is why really Mike and I would say your best approach is always to talk to your neighbor first. Absolutely. Right? You absolutely want to try to come to an agreement to do this if it's possible. Let me give you another scenario that I would say to you is probably the most problematic scenario, which is you cut those branches off and then the tree begins to die, and then it falls into your neighbor's house. Or you cut the roots underground. This is a very common scenario. The roots get cut. You may have noticed when you have trees along in urban areas where they plant them between the sidewalk and the street. And sometimes they'll come in and do street work. And then a few years later, the trees fall over. And what you find is that they've cut the root systems, and then the tree doesn't have the support it needs. And you get a storm or a wind and it falls over. You know, that's the scenario where you could have a neighbor. You would say, well, I was in my right to cut my branches, and I was in the right to cut roots that encroached upon my property line. And the neighbor's response is, yeah, but you caused that tree to die. If the tree died over a slow period of time, you might have a defense, but obviously you're getting yourself into a sticky situation now where you have done physical harm to a tree that's on someone else's property, and that may have resulted in that tree dying. That's why the best resort is to try to work this out.
Absolutely.
So the first scenario we talked about was the healthy tree. Then now this is the part, this is where Mike and I have handled cases, and Mike and I have recently talked about this quite a bit. We both have handled cases where neighbors were writing letters to their neighbor, telling the neighbor that this giant tree that's only 20 feet, you know, a lot of these urban homes are built right up close to the property line. You know, maybe a tree is 10 or 15 feet away from the house, but it is fully on the neighbor's property other than perhaps the branches. So the trunk is on the neighbor's property. It's a massive pine tree, 150 years old, 125 feet tall, but it's looming over someone's bedroom, and it scares them to death. And now it looks like it's dying.
Yeah, and that distinction is important here, because now no longer are we talking about parts of that tree on your property. The entire problem, the entire base of that tree, the unhealthy tree, is on your neighbor's land. So that idea of self-help no longer really applies, right? And that's because you cannot trespass onto your neighbor's property to go and try and remedy that tree. In other words, cut it down. So this scenario is a little bit different. You know, you'll ask yourself, all right, I see this tree. It's making me nervous. I'm concerned it's going to fall on my home. It's going to fall on my car. It's going to fall on my trees. You know, what do I do? And as Larry pointed out, we've handled cases where homeowners have issued letters. They've sent letters, regular mail, certified mail, send emails, send text messages, talk to your neighbor, but always follow it up with some sort of writing. And that reason is because you want to document that, hey, I saw this problem and I told my neighbor about it, and I asked them to remedy it. I asked them to investigate it. And what did they do? Because the scenario that would play out here, and it's unfortunate, is that that tree might eventually fall down, right? And that's where the damage occurs. And that's where this unhealthy tree presenting a hazard scenario turns into litigation or a lawsuit. So you always want to see if you can cut it off before it happens, right? And that would be ask your neighbor to see if they can remedy the tree.
And then, of course, if they're not going to do it, right, if they're not going to do it themselves, you can try to, you know, twist their arm a little bit by writing them that letter, certified letter with pictures, and you're sending a message subtly, if nothing else, that, hey, I'm making a record here, and if something happens later on, I'm going to sue you.
Absolutely.
And Mike, we want to make sure we zip through this because we're running short on time here. And then, of course, the last scenario we wanted to talk about is when all that has happened, right? So you've written the letters, you've taken the pictures, you've told the neighbor they need to take care of the tree and they don't, and then the tree comes down. You know, this particular slide talks about the distinction between rural and urban. And, you know, I'll leave it to you to read the slide later, but here's what I'll tell you about it right now. As a general matter, when you live in an urban environment where houses are closer together and many more people are in smaller spaces, the duty or the obligation to take care of your trees is higher than it is in rural areas where there are more trees than people and houses, right? So it makes sense. If you have 20 acres of trees and, you know, and there's no house nearby, but maybe the neighbor's not happy about some of these trees that are near the line, and there's no house nearby, there's no children playing nearby, the duty or the obligation there is not going to be the same, and is not going to be treated the same under the law as if you live in an urban area where there's more houses and more people than there are trees. So the causes of action that you're generally going to bring against your neighbor are going to be negligence and trespass. The trespass cases are the ones that involve the circumstances where there hasn't yet been a physical injury, a home or a person, and you're just dealing with the tree that's crossed the line that you don't want. That's called a trespass. That's what you're going to want to sue in those cases. Negligence claims are going to involve those circumstances where the tree has come across the property line and now done harm to your property. You can sue both in that scenario, in negligence and trespass. And as I defined earlier, negligence is the failure to behave as a reasonable person would, someone of ordinary prudence would have exercised under the same circumstances, right? So the court's going to look at a homeowner, for example, in an urban area that owns a tree that's looming over the bedroom of someone else. What care, and the tree looks like it's sick or it's dying, it has lots of cavities in it and missing branches. What kind of care would someone who got letters from the neighbor exercise under those circumstances? That's what the court's going to view the case as.
Yeah, and there it is, Larry, right? You know, where are we located? Was it urban? Was it rural? That'll dictate what the court sees as reasonable. You know, what was the appearance of the tree, right? Just because one neighbor says that tree doesn't look good to me, you know, if you take an inspection of it and you know, there's no decaying, there's no rot, there's no falling branches, no losing of leaves, you know, it would have been reasonable to leave that tree on the property. Again, that's a question that the court's going to have to answer. And generally speaking, when that neighbor, that owner of the tree, was told about the concern, what did they do? Did they hire a contractor to come out and look at the tree? Did they just throw the letters away? Did they ignore it? You know, all that kind of goes into this reasonable analysis that the court's going to undertake.
Right. And just in terms of what you might look for in the trees when you're looking at a neighbor's tree, obviously, if you see dead branches in the tree, if you see cavities in the tree, you'll see a picture here of the thinning canopy. That's the top of the highest part of the tree is called the crown of the tree. Typically, if you look up, oaks, by example, there's a blight going through southeastern Pennsylvania right now. It's killing a lot of oak trees. You'll look up at the top of an oak tree and you'll see no green leaves at the top. That's an indicator that the tree is sick. So a thinning canopy or problems at the crown. Things below the ground level are a little bit more difficult to determine. So root rot is very hard to see. But an arborist, if you think a tree is sick, an arborist can check that out. And then the next slide here. I think a very important thing I want to make sure we get to, let's skip this, is the statute of limitations, because we only have about 2 minutes here. In Pennsylvania, when we've talked about different causes of action. So in Pennsylvania, a negligence claim and a trespass claim is subject to the 2-year statute of limitations, and that begins to run at the time that the incident occurs. So with respect to property damage, it's the day the property damage occurs. You have 2 years to get that claim filed. If you were dealing with a breach of contract action, that's a 4-year statute of limitations in Pennsylvania. So the example here was February 7th, we're here, of 2023. You would have until February 7th, 2025 to file it. But I'll tell you, don't wait till the last minute.
Never.
No, because you could have problems in the court, you know, filing it, technical problems like we had tonight, which is why we've been short. You have been cheated out of giving us our full presentation, and the library closes at 7. But I want to thank you so very much for this great program. I really, really mean it. You guys know what you're talking about, and it is truly, you know, it's important, because I know that from the judges that have reached out to us, they keep telling us, you know, what's the law, or you have a conversation with a neighbor, like, you know, they're complaining about a tree. What's the law? So thank you so very much for your time, for your help, and everybody have a good night. And we will be able to circulate this PowerPoint to those who attend after the program is ended. Thank you very much.
Thank you, Lori. Thank you, Deb and Mike. Good night, everybody.
Bye. Good night. Thank you.